I know how the tax code works better than anyone.
I spend millions of dollars a year for lawyers and for accountants to do my taxes. I mean, they do a great job.
Nobody knows the tax code better than I do, okay? I know it better. I'm the king of the tax code.
I know more formulas. I know more about tax abatements. I know more about taxes than any human being that God ever created.
The Trump tax evasion case is officially underway in New York City. But with such a low penalty for guilt, what's the point? I'm Yasmin Khan with The Breakdown, and Trump isn't actually on trial here. The Trump Corporation and Trump Payroll Corp are. These are entities that, between the two of them, are charged with 17 counts of tax fraud, defrauding and falsifying business records, and conspiracy. The entities, while related to Trump's more extensive business dealings, specifically employ and pay Trump's top executives. The books are what's on trial, and the prosecution alleges that fraudulent tax schemes were used to pay bonuses and buy gifts and other perks for executives. But since an entity isn't a person, jail time isn't really a likely outcome for this trial. Instead, the looming penalty is a fine of just $1.6 million. For a Trump organization, that's chump change, so why all the fuss? First of all, here's what we're dealing with. The prosecution faces the task of convincing a jury that these practices are in fact fraudulent, but that can be a tricky task just by the nature of the content. It is boring and it's convoluted. The prosecution is attempting to incite Donald Trump's name in the trial, considering he's already an unpopular figure and he's a face to put with the fraud. On the defense side, the lawyers are trying to deflect from Trump himself, alleging that Alan Weisselberg is solely to blame for most of the charges. Weisselberg, who was the chief financial officer for the Trump Organization, has already pleaded guilty to charges of tax fraud and larceny, so he's an easy scapegoat. That said, Weisselberg has agreed to cooperate with the prosecution as part of his plea deal. His cooperation will result in a much shorter prison sentence for him at Rikers. On Monday, Susan Hoffinger, the chief of investigations for the Manhattan DA, said, quote, "This case is about greed and cheating on taxes. The scheme was conducted, directed, and authorized at the highest level of the accounting department. Weisselberg's testimony will give you the inside story of how he conducted this tax scheme." The prosecution wants to tie Weisselberg's testimony into the larger operations of the two corporations. The defense is asserting that Weisselberg is only throwing the corporations under the bus for his own misdeeds in order to get a shorter prison sentence. But for as big of a case as this could and probably should be, the fine these corporations are facing is negligible. Is it really worth it for the prosecution to pursue it? Well, as far as justice is concerned, yes. If people commit crimes, they're not supposed to get away with them. But with low penalties for criminal activity, large corporations are hardly deterred from committing them, and you can't really expect them to be. Instead, the penalties have more to do with reputational damage and loss of business, or rather, the potential loss of business. For instance, it may be harder for the Trump org to find creditors or partners to work with going forward. Also, the Trump org could lose federal contracts due to regulations that would prevent the government from doing business with fraudulent companies. In this case, if these two corporations are found guilty in this trial, that could mean that Trump may not be able to overcharge the Secret Service for staying in his hotels anymore. There's also the fact that this is just one of many trials against Trump and his entities. His whole reputation, which is somehow not already completely tarnished, could face further defamation if and when guilty verdicts are reached. And on top of all of that, this trial is bringing attention to the fact that the penalties for committing large-scale corporate crimes are simply not enough to deter crimes from occurring in the first place. Why are the fines so low? And why are the stakes just probable? Brandon Garrett, author of Too Big to Jail and law professor at the University of Virginia, said in an interview with Vox Media, quote, "There are good reasons we don't want to put important companies out of business just because a few employees committed a crime. But when you have a company that really is a breeding ground for crime, and where the crime was really benefiting the company, part of the business plan, then all of a sudden the dynamic gets really ugly. You worry that the very ability of the company to profit from its crimes helps it to remain above the law." He goes on to say, quote, "It seems like something of a worthwhile risk if you don't always get caught." So in this way, the fines associated with fraudulent activity could simply be seen as part of the cost of doing business. Garrett argues that companies found guilty of fraud should be, and sometimes are, subjected to increased scrutiny of their business practices following the guilty verdict. This could be the case with the Trump org. Now, the problem with low penalties for crimes, specifically corporate crimes, is the inherent risk of recidivism. Whereas individual criminals might bear the burden of a penalty more directly and without millions of dollars incoming to assuage their guilt, corporations could easily reoffend and not think much of it, especially in cases where corporations are fined for crimes without even being prosecuted. We already know that Trump doesn't have a guilty conscience, and we already know that he tends to surround himself with and employ others that are just like him in that sense. The lawyers working Trump's case already have extensive experience defending white-collar criminals, including members of New York's 5 mafia families. Now, the first witness called to the stand yesterday was Jeffrey S. McConney, the Trump Organization's controller and Mr. Weisselberg's deputy. The prosecution has requested that he be treated as a hostile witness, but the judge denied their request. Now, if granted, the request would have enabled the prosecution to better explain the line of questioning to the jurors. With the request denied, the prosecution faces the daunting task of explaining complexities to a jury that was already showing signs of wariness by the afternoon. In addition to the difficulty of the subject matter, Mr. McConney wasn't exactly trying to make things easier on anyone. Court reporters suggest that he embraced the convoluted nature of the trial, at times deflecting to confusing semantics-related responses. According to the New York Times, quote, Mr. McConney spent long stretches of time quibbling over fine distinctions in the Trump Organization's accounting practices. As the evidence began to emerge, it was less about any two individuals than it was tax forms, spreadsheets, and numbers. One portion of the afternoon was spent discussing the difference between W-2s and 1099s, another reviewing in detail how to read a general ledger. Now, as this trial and others against Trump go forward, the damage done to the overall Trump Organization, the Trump campaign, and the Trump brand will have to be seen. In the meantime, it's a lot to keep up with, and at the very least, it'll certainly keep spectators busy. All right, that's it for me. If you got anything out of this, please like and subscribe, and be sure to follow me over on Instagram and TikTok. Thanks so much.